Hi, my name is Hunter. I am in a group with J.R. and Wesley for the Supreme Court project, which I'll now start a course. So, first we have the selection, nomination, and confirmation process. Firstly, for selection, in order for this to happen, there clearly needs to be an open spot, either when a Supreme Court judge retires, or dies, or resigns. The president usually finds a candidate through their legal experience, their age, diversity, and their likelihood to be confirmed by the Senate, because why would you pick someone the Senate doesn't like? Nomination. This is when the president announces who he's nominating. Pretty simple. He tells people, hey, and he also tells the Senate, hey, I'm nominating this person. And then the confirmation process. The nominee answers a huge set of questions from the Senate in public hearings held by the Judiciary Committee. The Judiciary Committee then votes on whether or not the nomination should go to the full Senate for voting. You guys already learned this, how the Senate works and the House of Reps stuff. So it goes through that whole process. So it's very long and difficult, but it's good because it quality checks on who the people are, and it takes into account what side of the political spectrum they tend to lean on, like whether they're conservative or liberal. It's good to have a good mix of both within the Supreme Court. And when the Senate approves them, they officially become a Supreme Court judge. And this brings me to the next section of our current judges and their backgrounds a little bit. The first judge is John G. Roberts. He's the Chief Justice of the United States, who was born in Buffalo, New York. He went to Harvard for law. He worked in the U.S. Court of Appeals for a while until he was eventually appointed to the Supreme Court in 2005. Next is Clarence Thomas. He is an Associate Justice who was born near Savannah, Georgia. He graduated from both the Holy Cross and Yale Law School. He had many jobs related to government, which got him his position, and he was nominated by George H.W. Bush in 1991. He's been on there for a while. And third, Samuel A. Alito Jr. He's an Associate Justice, born in Trenton, New Jersey in 1950. He went to Princeton and Yale Law School. He worked in many jobs related to law, such as a law clerk for Leonard Garth, and was an assistant attorney in New Jersey. He took his seat in 2006 for the Supreme Court. Next is Sonia Sotomayor, however you say that. She was born in the Bronx, New York, in 1954. What a time to be alive. She went to Princeton and Yale Law School. She was an assistant district attorney in New York County, and also went to court over international commercial matters in New York. She took her seat in the Supreme Court in 2009 after being nominated by President Obama. Fifth, Elena Kagan. She is also an Associate Justice who was born in New York, 1960. She went to Princeton, Oxford, and Harvard Law School. So she has a lot of experience. That got her nominated by Obama in 2010. Neil M. Gorsuch. He's an Associate Justice born in Denver, Colorado. He went to Columbia University, Harvard, and Oxford. He taught at both the University of Colorado and George Mason University. He was nominated by Donald Trump and took a seat in 2017. Brett M. Kavanaugh. He is an Assistant Justice and was born in Washington, D.C., our very lovely capital of the United States of America. And he graduated from Yale College and Yale Law School. He was an attorney in the Office of the Solicitor General of the United States, so he has direct experience with government, and also was Associate Counsel in the Office of the Independent Counsel. He was nominated for the Supreme Court by Donald Trump and took his seat in 2018. Amy Coney Barrett, the eighth one. She is an Assistant Justice and was born in New Orleans, Louisiana in 1972. She went to Rhodes College and Notre Dame Law School. She served as a law clerk for Lawrence H. Silberman in the U.S. Court of Appeals for the D.C. Circuit and taught law at Notre Dame Law School, where she graduated from. She was nominated by President Trump and took her seat in 2020. And for our newest Supreme Court judge and our final one, Ketanji Brown Jackson. She was born in Washington, D.C. in 1970, went to Harvard Radcliffe College and Harvard Law School. She was a clerk for Patty B. Saris of the U.S. District Court of Massachusetts. She was also an attorney for the U.S. Sentencing Commission. She was nominated by President Biden and took her seat in the Supreme Court in 2022. Next, we will describe the process used by the Supreme Court to decide cases and determine the constitutionality of the laws, of course. So, first, we have the petition for a writ of certiorari. Don't know how to say that. So first, the parties asked the court to review a lower court ruling, and then like a lower court ruling would be any court below the Supreme Court, because obviously the Supreme Court rules over all. And usually a writ of certiorari, the Supreme Court receives about 7,000 to 8,000 petitions of these every year. And next is the rule of 4, which is, you've probably heard that before in class. If 4 justices vote to hear the case, the court grants it certiorari or cert, which means they'll hear it out and they'll vote whether or not the court was right or the person was right. Whoever was involved, they pick a side. So if just 4 justices agree to hear something, it's the rule of 4, and the case goes to the Supreme Court officially. Briefs submitted. Both sides submit their written arguments. There's amicus curiae, friends of the court, when briefs are filed by interest groups, governments, scholars, etc. And then we have the oral arguments. This is when the lawyers get each side 30 minutes to present their case and all the information they have for their side. And then the justices ask intense, rapid-fire questions to, try to throw them off their game. And then the conference, justices meet privately, no clerks or others allowed, just like a real court. They discuss the case and take a preliminary vote. So it's basically their first impression. Then we have the opinion writing. The senator justice in the majority assigns the writer, and the writer drafts circulate, and the justice negotiates changes. Final decision released. This is when the opinions are released to the public and they get to hear what the Supreme Court decided on based on the writing, conference, oral arguments, all the process that happened before. And then the decisions determine the constitutionality of what was being fought for in the Supreme Court via judicial review established in Marbury versus Madison. Next, we have the importance of opinion writing, and I will describe the 3 different types of opinions. So first off, there is the majority opinion. This is an opinion written by someone who was in the majority/winning vote. This opinion becomes the official precedent. The concurring opinion is when justices agree with the results, but for different reasons. They can see the positives to the decision for separate reasons and come to a consensus. So, this leads to the dissenting opinion. This is written by a justice who does not agree with the majority opinion. This may influence future changes in law or future court rulings. So basically, the majority opinion is written by whoever won. The concurring opinion is like, yeah, I agree they should win, but not for that reason. And the dissenting opinion is, I don't agree with that at all. And here we have a background for one of the currently pending Supreme Court cases, and we picked Villarreal versus Texas. And in this case, we get to see how the justices each uniquely rule and their reasoning behind it. But first, the question presented is, whether a trial court abridges a defendant's Sixth Amendment right to counsel by prohibiting the defendant and his counsel from discussing the defendant's testimony during an overnight recess. Very important. So firstly, we have John Roberts, the Chief of Justice, and his prediction was, yes, the defendant will win. So further on, when I say yes, the prediction, that means they want the defendant to win. And his reasoning is that he's often shown concern for fair trial rights and institutional legitimacy. So he may view a blanket ban on counsel-client discussion during recess as undermining the fairness of the process. Next is Clarence Thomas. We predict he will say no. The state wins. This is because Thomas tends to favor law and order and deference to trial court discretion. He might defer to the state's argument that the restriction is necessary for the order of fairness. Next is Samuel Alito. We also predict he'll say no. Alito often leans towards prosecutional prisoner control arguments and may be skeptical of expanding defense side procedural rights. Next is Neil Gorsuch, which we predict he will say yes. He has defended defendants' rights in the past 4th and 8th Amendment cases. He may view this as a 6th Amendment protection deserving robust defense. Next is Brett Kavanaugh, which we will predict will also say yes. Kavanaugh has shown concern for fair trial and due process protections. He's barring counsel from discussing testimony overnight may strike him as overly restrictive. Amy Coney Barrett, we also predict she will say yes. Barrett's jurisprudence often respects individual rights under the Constitution. She may side with defending the adversarial process's integrity, so she thinks that the Sixth Amendment was violated. Next is Sonia Sotomayor. She's frequently sympathetic to criminal defendant rights and likely to support a ruling favoring exactly that. Next is Elena Kagan. We predict she'll say yes. Kagan generally supports robust constitutional protections in criminal cases and may view the ban as unjustifiable interference with counsel's role. And lastly, Ketanji Brown Jackson. We predict that she'll also vote in favor of hearing this. Jackson, with her background as a federal public defender and her concern for procedural fairness, is highly likely to support strong defendant protections. So in the end, we think the vote would either be 7-2 or 6-3 in favor of the defendant if this got heard. And that's basically all that needed to be said.